Yeah, it's gonna be a longer video today. Spoiler alert, I guess I should say. Yeah, Yak Gotti stays, Shannon Jackson goes. But it was something that happened I found awfully interesting. But you know what? Let's run the Shannon Goes Home video first, and then we'll run the longer Diamante Kendrick video. Sounds good? Let's go.
Nobody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems. Because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem, and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years. And nobody's going to say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572, so you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there, so there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing, if we could put on the sentencing sheet that all these sentences are run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you or the court where I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So, don't be late. Don't miss that appointment because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right. So, at this time, is there anything else from either party?
Just Mr. Sharp had recommended. I have no intention of leaving my office anytime soon, at least voluntarily. So Mr. Sharp and I have built up a point of trust and communication over the years. I have no problem with Mr. Sharp reaching out to me if there's any exceptions that are necessary. That's good.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you.
All right. If there's nothing further, then all parties are excused.
Thank you, Your Honor.
I know there's a bunch of people doing toy drives and stuff like that, but we out here in the field with it. So, hey, if you are free and you are around Forest Park or Atlanta and all that stuff, man, pop up on us, 803 Forest Park, Georgia. Hit up, answer the bell if y'all want to donate toys and stuff like that. Hey, whatever you want to do. And if you want to directly help out, hit the Cash App, $ Steady Nash. It will directly go to a family directed by the recent hurricane. Other than that, let's get y'all back to the video. And if you feel like, hey, I don't want to donate because I don't know where the money is going and stuff like that, please keep your money. I have no reason to steal from anybody. I got a couple of messages talking about where's the money going? Where's the money going? It's going to go to a family. I'm already donating my own money. I've already given away thousands. So please keep your money if you're thinking like that. Not sorry. I found it extremely interesting today that Matt Sharp did not call him Shannon Stillwell. He called him Shannon Jackson. Now, if I ever interview with Matt Sharp, I'm going to ask him, hey, why were you calling him Stillwell the whole time instead of Jackson? And I believe he's going to say so he can disassociate when he was being called Jackson with Stillwell so that it wouldn't play into the mind of the jurors. That's what I would do. All right, let's get to the brass tacks of this. I didn't hear my guy Matt Sharp argue for, unless I just completely missed it, for Shannon to basically go ahead and go to Texas. So it seems like to me he's going to be staying in Atlanta. And I think the reason why, and I ain't talked to nobody about this, and I really don't want to know the answer privately or publicly. Well, privately I don't want to know the answer. Publicly, he could put it out there. I think the reason why he's still going to remain a resident of Georgia is because his kids. He has kids here. A couple of them. So I believe that's the reason why. He got banished from Atlanta. The judge decided to do that. That wasn't a prerequisite. That wasn't a co-requisite of the probation. No. She added that. So now I'm thinking to myself, like, damn, I'm glad we didn't have Belinda. Because y'all got to remember, Belinda was supposed to be on there as well. I think she was the second one. I think she was the second judge, if I'm not incorrect. Anyways, it is what it is for that. We're not going to see Paige Reese Whitaker anymore. She admitted that basically in the Miles Farley, the rest of the YSL gang, their stuff, that is going to go to another judge and be heard and all of these things and stuff like that. I'll put out that video later, probably in a couple of hours after this. What is it, 1:30, whatever the hell. So we'll put that out at about 6. Yeah, about 6. So y'all on lunch right now. So by the time y'all headed home, I got a long video for y'all there. But shout out to Shannon Jackson. Hopefully everything works out for him. I found it interesting that she said basically, hey, people who have high school diplomas, they don't F up. They don't end up in the prison system. All right. If he wants to go get a job, he ain't get no damn job. He about to go rap. What are you talking about? Like, his team is already, I don't know if it's his wife or if he has a manager. I don't know. Don't really care. But his team is already looking at certain things like, hey, what song you like? This one or that one? That one or this one? Hit A, hit B. So that part already jumped itself out. But I think he'll be all right, man. I think he should do some interviews, run his bread up that way, go on major platforms and share his story, and hopefully it's a different arc. I'm sorry. I don't want to see Shannon Jackson talking about shooting up, killing, bang, bang, and all that stuff and everything, and I beat 2 bodies and all this. I really don't want to see it. That's me personally. He can do whatever he want to and stuff like that, but I think his story would go much further than his rap career if he just came out, opened his heart up, talked about family, talk about family, talk about being married, talk about reform in jail, talk about all this stuff and everything like that, and get rid of the street shit. Like 100% get rid of street code, street talk, street all this, bro. You got paperwork. You do. You recanted on the paperwork, but bruh, they exposed you for telling. It just is what it is. You went back and reneged on it, or however in which it came out. Nobody's going to care about that paperwork or anything like that. And I only bring it up because basically it seemed as though you wrote a letter essentially saying, man, I'm sorry that woman was killed. One of the best ways you can repay that young lady who was killed where that bullet was meant for you is you go change your life and you go live for everybody else that are not here. See, some people believe the best revenge that you have is to go out and go do something to somebody else. That's vengeance, bro. The best revenge is honestly going out, doing well, and proving the people who love you right while making the people who despise you want to be you. Yeah, it's not, shining on them and making them hate on you for you shining. No, it's them looking at you saying, I want to be like him. I want to do like that. But like I said, the paperwork stuff, it's not going to matter. Nobody's going to care about it at all. The people that dislike you, of course, they're going to put that out again and be like, see, this is what he did, this is what he did. And if he does have a rap career, I think people will care about his rap career for probably about a year. And then he'll have to get better and get better and get better and get better. But honestly, bro, go tell your story. Really be a changed man. I hope. This is just me hoping. I ain't talked to him, anything like that, but I hope that young dude is able to go out there essentially and start to share his story and start to preach to the youngins about the good and about the bad. Bro, you took a bullet to the head that missed at the green store. They try to kill you multiple times. You're here for a reason. If you think that reason is going back and rapping the dumb shit and all that stuff, I gotta disagree completely. And I'm not saying, he'd be wrong for doing it. I'm just saying, I think the money, the influence, and the longevity of everything would go better if he decided to turn another leaf. But I have no idea, man. Let's get on with the Yak Gotti part of this. I ain't gonna lie. This felt like a gut punch if you was watching it.
Are you ready? Yes. Okay, this is 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick. I'm all right. How are you doing? I bet you could if you wanted to. I'm Judge McBurney, and we are going to work through bond in your two cases. You've got one case that's assigned to me in which you're charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only or through the duration of these two cases?
Through the duration, Your Honor.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus, hear from her about why you're a good candidate for bond in these two cases and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me when you're ready.
Good morning, Your Honor.
Good morning.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to be given a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're going to get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to give him a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom? Or?
No, he was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly, because he was in 1C.
Yes, Judge.
But in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that there was the facts did not arise to an aggravated assault, but a battery. And I know that, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are going to work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working for, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, and I have pictures ready to present if the court wants to see, but I'm an officer of the court, but he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these 2 cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot. It's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. There'll be 123 Main Street, and they'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level. And basically for his own safety. You're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place. And the next day there's a dead guy in the parking lot. And it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're going to be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the two cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. I'll look in what's in the chat. Oh, okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you, having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who have also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder, the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your
Kendrick.
Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but with respect to Mr. Kendrick, it's essentially he's saying, "What else am I going to do? It's about respect. They're stealing my stuff. I got to do something." So I would disagree with the assertions that this is just a battery, and I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does in fact have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation. Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to a 15 years to serve 2 sentences, with the balance of the first 8 years on probation, with the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents, 10 are allegations of violence and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. In many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assault. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, just Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the 2 cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation at a bond hearing or at a sentencing hearing. That's your best forecast, with maybe one exception.
That's correct.
Okay, all right.
Thank you.
Thank you. Ms. Bumpus, want to give you the last word. I'm going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not two separate crimes. This 2015 is the federal case.
All right. So they just was dual sovereigns and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate acts. And in me saying that, I don't know if this brings any or can help us get clarity on the warrant because my client's understanding is that the federal probation then trumped the state probation and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault of Mr. Wimberly. And you know that's how it flows. And so if that warrant is out there, then we need to work through that and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted or it's dismissed, or I don't know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. It's like, all right, and this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes bond moot in these two cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure. Good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these two cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these two cases.
And Your Honor, how am I going to, can someone email me about the probation?
I will keep everyone in the loop.
Okay, thank you, Judge.
All right, Mr. Rao, anything else from the state? All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. We'll get it
First,
back.
I'm going to assume it's a federal hold because I don't think any attorney worth their salt will literally, federal probation violation. I don't think that Kayla would have missed that by a mile and a half. She's not bad at what she does. I'd have to give her an A- for today, though. She was able to articulate her point, but the pauses that she had, it just didn't flow well, right? Added with this one simple thing. When speaking and try to appeal to people, the phrase I is always supposed to come from experience, but also in the ways of the court, it's best if she just puts the family, the concern, the court should be aware. These phrases, but saying stuff like, I have a problem with this and with that, I don't think it really boded well. I don't think it had an effect, but as far as like down the road kind of thing and all that stuff and everything like that, but she did well. I think you people are so used to this flat out just get straight to it and, hey, he's supposed to go home because we are sitting here looking at all of this stuff and it don't match up. Let's understand something. From what the state painted about Diamante Kendrick is bad. I don't give a damn how nobody see that. It is. Y'all heard what they said. Every single time he was the aggressor is how they're painting it due to the video that they had. They said he stayed in that cell and whooped Buddy ass all damn day. That's crazy. Hey, spin it how y'all want to. Listen, all right, he innocent of all charges. He didn't do anything like that. Cool. That's for them charges. Inside of that jail, whole different thing. Now, that can easily be explained. Like, I had to do that because he had been threatening me and all of this stuff and everything, and I was running a search of his cell because he told me he was going to kill me. He had a knife, and I just don't trust the guards to do their job because there's another nickname for Rice Street that I didn't even know about because apparently nobody told me. They call Rice Street Knife Street. It makes sense, but yeah, they call Rice Street Knife Street. So there could be that. The other stuff, him being charging dude and fighting him and stuff like that. Once again, if he said he had a knife on him, bro, I'm not about to wait for you to find out. I'm about to get on your heels. So that one right there, yeah, I think there was no statements made. I think that's what's ultimately screwing him over is nobody made statements, and essentially the state and the Fulton County Sheriff's Office are allowed to paint the illustration for you. So if the cops are going to paint it and the DA is going to paint it, they're not going to paint that thing favorable for you, especially after you just took 2 years plus and made them look stupid on TV. So is there a bit of retribution with inside of this? Yes, because all in all, regardless of anything, he 100% should be able to go home. But one thing Kayla pointed out, and I'm glad she did, and this is why I couldn't give her anything less than an A-. She was going to end up on an A spectrum any doggone ways, regardless of how the rest of a couple of people feel. Bruh, the feds picked up charges. The state tried to paint it. It looked like something on my beard. Oh, oops. That's just a shine. Anyways, the state tried to play it like, oh, this charge and this charge are two different things. No, fool. The feds came and they picked it up. So I'm glad she was able to paint that out and point that out because, honestly, the state playing dirty. The state know good and damn well what the hell they doing. Actually, the battery part of the assault part basically is what was granted to him. The assault part wasn't there unless I mixed them up. Sometimes y'all know how I do this. I call Miss Love Miss Hilton for a whole video and then vice versa. So, yeah, one of those didn't match the other is how I'll leave that right there. So when you're saying that and the judge basically like, yeah, I don't find enough evidence to do this and to don't do that, and then the state goes ahead and just amps up the charges, that's retribution. It's illegal. But the way in which they do it, it's not illegal. It would not surprise me, and I hope to God this doesn't happen, if they try to hit him with another RICO. It just wouldn't surprise me. Right now, from how it's looking, He gonna be in there probably for another week, and he'll come back home after that. And if they come back home, he'll be fine. But it just looks like, hey, he was on federal probation, and they let his ass, federal parole. He's on a parole hold, and basically that's what's getting him up out of here. So that warrant part of that, I think that's what that is, because we just got revealed that today. And I really, really hate how they trying to paint it that he ran and that makes him guilty of something. First off, how did he know? And where did the state prove that he knew he had a warrant for a damn RICO? Bro, let me help y'all out. If I'm walking up to a house and the police are coming, I'm going the other way. What say you? And if it look like the police might be thinking I got something to do with this, I'm going to walk a little bit faster. Hell, I might even run. I'm not voluntarily turning myself in to nothing if I see the police going to a house that I was at. That don't even make sense. So they keep trying to act like he was just supposed to walk in there like Katniss and go, I volunteer. No, what the hell? No, that was just dumb. I really, really despise that part of the state doing the dirty shit that they was doing. He need to go ahead and go home. Bruh, listen, even though he's charged with some aggression and with some leading some cats to beat some ass in there and whooping cats with an extension cord, shout out to my mom and my grandma, they used to beat my ass with an extension cord. Even though that's the case, and even though they're saying that he charged a dude who had a knife on him, it all happened in jail. Like Kayla said, he shouldn't even been there. Shouldn't have even been there. And to make matters worse, y'all try to do all this on the hush-hush and then come back and kill his ass as a contingency plan. This right here was contingency and to add up. So no matter what, he was going to be screwed. So they probably were thinking to themselves, oh, we can get him on this and get him on that because we just showed him being gang and all that stuff. So we might be able to get him with the RICO. We add on the RICO, maybe we could add this right here and get him a little bit of prison time. But the state playing dirty as hell. Kayla's right. He shouldn't have been there. But even though he was there, these are the rules of jail. So it's really not on the damn defendant. It's really on the jail. Because if I'm paid to protect people away from people because they're in jail and they go ahead and don't protect them, whose fault does that lie on? Mine. Then y'all watch the whole shit on camera. So you telling me y'all watched all this stuff happen on camera and y'all did nothing? This man sat up here and played bunk beds and y'all did nothing? That falls on the jail. That doesn't fall on him at all. They don't know how to manufacture phones in jail. They don't know how to manufacture a whole lot of stuff in jail. But they have it because of the jail. So I, myself, am not about to sit here and say, you know what, bro, the state, you know what, y'all got it. No, y'all flat out wrong. But y'all let me know your thoughts on this one. It boggles my effing mind.